What happens when Hollywood greatness walks into the halls of America's highest court, not to act, but to argue constitutional law? In this gripping true story, Academy Award winner Denzel Washington stuns the U.S. Supreme Court by dismantling centuries-old precedent with a level of legal brilliance no one expected. What began as a patronizing interruption by Chief Justice John Roberts became a historic moment that challenged power, redefined justice, and inspired a generation. In this video, you'll witness a masterclass in courtroom poise from an unexpected legal scholar, the dramatic shift of power inside the Supreme Court, a decision that reshaped America's civil forfeiture laws forever. If you believe brilliance knows no boundaries, and that preparation can turn silence into power, then this is the story you need to hear. Stay until the end, because what Denzel did in Courtroom 3 didn't just win a case, it changed the law. There are moments in American history when the courtroom goes silent not from fear, but from awe. Not because someone shouted, but because someone didn't have to. On a crisp Monday morning in Washington, D.C., a name appeared on the Supreme Court docket that made more than a few clerks and court watchers do a double take: Denzel Washington. Some thought it was a mistake. Others assumed it was another PR stunt, a celebrity weighing in on social issues, probably with a ghost-written brief, maybe even for a headline boost. After all, actors don't belong at the lectern of the highest court in the land. That's where pedigreed lawyers, Harvard graduates, and seasoned legal strategists belong. Not Hollywood royalty. But what happened next in Courtroom 3 of the United States Supreme Court wasn't a cameo. It wasn't theater. It was a reckoning. Denzel Washington stood at the podium in a tailored navy suit. No entourage, no script, no spotlight. Just him, the law, and the 9 most powerful legal minds in the country staring back. Among them, Chief Justice John Roberts. The marble walls loomed behind Denzel like centuries of tradition pressing down. The courtroom was packed. Law professors, journalists, veteran attorneys, and law students all leaning in, waiting to see what the actor would do. That's when it happened. Before Denzel could finish even a minute of his prepared remarks, Chief Justice Roberts leaned forward with that familiar half-smile, the kind used to test nervous young attorneys, and dropped a line that would echo across American legal culture for years to come. Mr. Washington, I find it difficult to believe that someone from your background fully understands the constitutional implications of your position. The room froze. Clerks exchanged uneasy glances. A journalist's pen slipped off his notepad. Justice Sotomayor shifted in her chair. And Denzel? He didn't flinch, he didn't raise an eyebrow, he didn't fumble for words. He simply met Roberts' gaze with the same quiet power he's shown a million times on screen. Except this wasn't a movie. This was real. And the line he was about to deliver would change everything. Most assumed this would be the moment the illusion shattered, that Denzel's brief would buckle under the scrutiny of a Harvard-trained Chief Justice, that the courtroom would politely clap and move on. They didn't know that this man, the 2-time Oscar winner, had quietly spent 5 years earning a law degree in secret from Howard University, poring over founding-era case law between film shoots, spending late nights in library archives while the world celebrated his box office wins. This wasn't Denzel the actor. This was Denzel the constitutional scholar, and Roberts had no idea what was coming. As Chief Justice Roberts finished his patronizing sentence, Denzel opened his well-worn leather binder. His voice was calm, his tone measured, but behind it was a storm of knowledge that was about to sweep through the court. Chief Justice Roberts, he said evenly, perhaps we should examine the textual and historical evidence together. Then, he flipped, not searched, not shuffled, but flipped directly to the section in the Constitution he had anticipated would be questioned. He was prepared, precise, and deliberate. From that moment on, the courtroom dynamic shifted, because what was supposed to be a takedown had just become a takedown in reverse. Denzel Washington, the man many assumed was there to play lawyer, wasn't playing at all. He had come to make legal history, and over the next 50 minutes he would turn the highest court in the land into a masterclass in humility, preparation, and the power of walking into the most elite room in America and proving that brilliance doesn't need permission. This was just the beginning. Long before he stood beneath the vaulted ceiling of Courtroom 3, Denzel Washington had already spent years preparing for this moment, just not in the way anyone expected. It didn't start with a courtroom. It started in silence, during breaks, between blockbuster shoots, in trailers lit by vanity bulbs, on red-eye flights between press tours and red carpets. That's where Denzel first began reading legal briefs, not scripts. Supreme Court opinions, not screenplays. Few knew, fewer believed it when they heard whispers of it. But Denzel Washington, Oscar winner, national icon, beloved by millions, had spent 5 years studying law in secret. And he wasn't auditing classes at some Ivy League school for vanity. He enrolled at Howard University School of Law, one of the most historically significant institutions for black legal scholars in America. While the public praised his roles in Training Day or Fences, Denzel was in the back of the law library, dissecting footnotes on due process, originalism, and the takings clause. He didn't need a JD to boost his career. He didn't need another accolade. What he needed was clarity, purpose, a way to channel his voice beyond cinema, and it was a single case that gave him that purpose: Henderson v's Department of Justice. To most, it was another procedural challenge about property seizures under civil forfeiture. To Denzel, it was something else entirely: a quiet tragedy that echoed through American communities like his own. The government had seized several blocks of real estate in a majority black Philadelphia neighborhood, not because the owners committed crimes, but because someone else had conducted a drug transaction on the sidewalk nearby. The government didn't arrest the owners, didn't file criminal charges, just took the property and kept it. To legal observers, it was business as usual. But to Denzel, it was a warning sign, a signal that something deeply constitutional had been forgotten. So he filed an amicus brief, 40 pages of originalist legal analysis, no ghostwriter, no co-counsel, just him, his research, and 5 years of stored determination. The legal world didn't know how to handle it. "He's just doing this for attention," one pundit wrote. "This is celebrity activism," said a retired Solicitor General. They weren't reading what he wrote. They were reacting to who he was. But behind the scenes, something else was happening. Clerks at the court began whispering about it. Law professors shared excerpts in classrooms, because buried in those 40 pages was something no one had seen before. A novel theory on the Fifth Amendment's takings clause, tracing its original meaning beyond modern interpretations, back to Madison, Jefferson, and state-level judicial opinions from the 18th century. It was dense, it was brilliant, and it was dangerous to the status quo. So when Denzel petitioned for 10 minutes of oral argument time, a rare privilege for an amicus, many expected the court to decline. But then something surprising happened. The clerk of the court approved. Then the date was set. It wasn't a PR stunt, it wasn't about fame. It was about precedent. And for Denzel Washington, this wasn't about his name. It was about the names on deeds that were being erased by civil forfeiture laws. About grandmothers losing homes, community centers shut down, and neighborhoods erased not by crime, but by bureaucracy. So he studied. Every night. Every morning. He didn't prepare to impress, he prepared to protect. And when he stood in that courtroom, it wasn't as an actor, it was as a man carrying the weight of forgotten voices. This was why he was there, and as the court leaned in to listen, they would soon realize he wasn't just there to speak, he was there to be heard. Chief Justice Roberts wasn't known for making things personal, but today, in front of a packed courtroom and live recording devices, he crossed a line. He hadn't even waited a full minute before interrupting Denzel Washington's carefully structured opening. It wasn't a question. It was a statement laced with quiet dismissal, framed with legal formality but sharpened with a personal jab. "Mr. Washington, I find it difficult to believe that someone from your background fully understands the constitutional Implications of your position. The words were still hanging in the air, sharp as glass, when the courtroom responded with stunned silence. You could hear the soft rustle of pages being turned, the breath people hadn't realized they were holding. This wasn't just scrutiny, it was condescension. It wasn't about the case, it was about who had dared to bring it. But Denzel didn't. Coil. He didn't raise his voice, didn't plead his case like a man wounded. He responded like a man who had expected to be underestimated and had come prepared. Chief Justice Roberts, he said calmly, I believe my argument aligns with the original understanding of the Fifth Amendment as expressed by Justice Thomas in his concurrence in Timms v. Indiana. But if you'd like, we can examine the textual and historical evidence together. And then, he reached down, flipped open a binder, and produced something few advocates ever dare present in open court. The physical Constitution, annotated with margin notes, bookmarks, and cross-referenced footnotes in his own hand. The mood in the room shifted. What had begun as a thinly veiled insult from the Chief Justice now teetered into dangerous territory for Roberts himself, because in that moment, the actor they expected to falter didn't. He leaned in. With the court's permission, Denzel continued, I'd like to direct attention to the 1827 case of the Palmyra. A ripple of reaction flickered across the bench. That case, one of the earliest civil forfeiture precedents, had tripped up even seasoned attorneys. Justice. Story's opinion in that decision was complex, technical, and often misquoted. Most expected Denzel to step on a minefield, but he didn't. He navigated it with surgical precision. While the Palmyra did permit forfeiture without a criminal conviction, it was, in fact, a maritime seizure, a piracy case. Justice Story explicitly wrote that the vessel, not the owner, was treated as the offender. That legal fiction made sense only when personal jurisdiction wasn't possible. He paused, scanning the bench. What we have today in Henderson is not a ship committing piracy in foreign waters. It's a community center, on land, in a black neighborhood. And the owners are fully subject to the court's jurisdiction. No theatrics. No anger, just facts, delivered with unshakable command. Justice Alito leaned forward, narrowing his eyes. That's an interesting historical distinction, Mr. Washington. But what about more recent precedent, like Bennis v. Michigan? Denzel didn't blink. Justice Alito, I believe Bennis was wrongly decided, and I'm not alone. Justice Thomas and Justice Ginsburg dissented in that case, despite their vastly different judicial philosophies. The tension Bennis created has been unresolved. This is the case that allows the court to correct it. He turned a page in his notes, pulling up cases like Austin v. United States and Timms, linking them not just to constitutional doctrine, but to moral clarity. And for the first time, the justices weren't just questioning him, they were listening. Even Roberts, because whatever expectations he brought into that room, whatever assumptions he had made about Denzel Washington, about celebrity, about credibility, were evaporating with every calmly delivered citation, every unflinching response. What had begun as a courtroom ambush was becoming something else entirely, a masterclass in history, in law, in dignity under pressure. The ambush had failed, and the man they tried to corner was just getting started. The courtroom no longer pulsed with doubt. It buzzed with a quiet curiosity now, a growing realization that something historic was unfolding. Denzel Washington, once assumed to be out of his depth, was steadily building something undeniable. A constitutional argument not just rooted in theory, but planted deep within the soil of American history. And then came the moment no one expected, a master class in memory, legal comprehension, and deliberate delivery. Justice Brett Kavanaugh, who had remained silent up until now, leaned forward. Mr. Washington, your historical argument is compelling. But let's talk practicality. Civil forfeiture has become a cornerstone of law enforcement. Are you suggesting we get rid of it entirely? This was a pivot, a subtle reframing. Kavanaugh wasn't questioning the history anymore. He was wrestling with its implications. Denzel didn't hesitate. Not at all, Justice Kavanaugh. I'm suggesting we restore it to its rightful place, within constitutional boundaries. He spoke clearly, decisively, laying out a proposal not just for this case but for the future of due process. Forfeiture is still appropriate in maritime cases, customs violations, and situations where the government lacks jurisdiction over a suspect. But when the government can bring criminal charges, and chooses not to, yet still seeks to seize property, then both the Due Process Clause and the Takings Clause impose heightened obligations. Several justices nodded, including Kagan, who began taking notes. Then Chief Justice Roberts attempted to regain control. Your brief cites several state court decisions from the founding era. Frankly, most of them aren't widely taught or cited. How can we trust these as indicative of mainstream legal understanding? This was the kind of question designed to knock even confident advocates off balance, to suggest their research was fringe, their argument a cherry-picked anomaly. Denzel paused, then offered a measured smile. "I'm glad you asked that, Chief Justice." Then, without looking down, he proceeded to list 8 separate state Supreme Court decisions by name, year, and holding. From Commonwealth v. Blaine, 1794, to State v. Klein, 1849. He described how each case treated property rights, the evidentiary standards applied, and how, collectively, they revealed a deeply rooted skepticism toward non-criminal forfeiture. It wasn't showmanship. It was scholarship. Far from being outliers, these cases reflect a nationwide consensus, across state lines, across ideologies, across eras, that property cannot be taken from innocent citizens without meaningful due process. The courtroom again went quiet. Justice Elena Kagan spoke up. "Mr. Washington, this is remarkable. Did you work with a team of legal historians on this?" For the first time, Denzel showed the faintest trace of personal pride. "No, Justice Kagan. I conducted this research myself. During my studies at Howard, and in the years since, I visited archives, studied original documents, and followed the citations wherever they led, even if they led to places the casebooks overlook." A buzz swept through the gallery. This wasn't just a legal argument. It was a resurrection of forgotten law. Denzel hadn't come to entertain. He had come to illuminate. Justice Sotomayor jumped in, redirecting the conversation back to the heart of the case. "And how does that understanding apply to the property seized in Henderson?" Denzel turned directly toward her. "Justice Sotomayor, the seizure fails on every front. First, there's no evidence the owners were involved in or even aware of the drug transaction. Second, the connection to illegal activity is tenuous at best, a sidewalk incident on public ground. And third, there's no identifiable public use being served by this forfeiture. The property was taken to fund general government budgets, not to repair harm, not to serve justice." He took a breath and then delivered the line that would make headlines for days. "A constitution that permits this kind of taking is not protecting property. It's protecting power." For a few seconds, even the justices were still. He had taken them through time, from 18th century maritime law to the streets of modern Philadelphia, and shown them how the same words could either shield liberty or rationalize its erosion. And just like that, the courtroom knew the real trial wasn't about Henderson anymore. It was about the court itself. Would it choose precedent or principle? There's a subtle sound that rarely escapes a courtroom, especially at the Supreme Court level. The sound of pens hitting paper in unison. But as Denzel Washington continued to speak, the justices, those who had initially prepared for a 10-minute celebrity lecture, were writing notes, quotes, citations. The shift was palpable. Justice Clarence Thomas, famously silent during oral arguments, was leaning forward, his gaze locked in. Justice Amy Coney Barrett nodded slightly, almost imperceptibly. Justice Kagan had long stopped frowning. Instead, she was circling phrases. In her copy of the brief, even Chief Justice Roberts, once skeptical, now sat back, hands steepled, his tone neutralized. It was no longer about Denzel's background. It was about his brilliance. Justice Barrett broke the silence. Mr. Washington, your brief makes an interesting claim about the interplay between the Due Process Clause and the Takings Clause, an argument I haven't seen developed in this form. Could you expand on it? Denzel didn't miss a beat. Thank you, Justice Barrett. While these clauses are often analyzed in isolation, the founders envisioned them as complementary. You can't properly take something, especially property, if you haven't first afforded fair process. He reached into his binder, pulling out a carefully preserved photocopy. This is a letter written by James Madison to Thomas Jefferson in 1788. It's rarely cited, but in it, Madison makes explicit the linkage between due process and property protections. He wrote, "The seizure of a citizen's lands without legal charge and without recourse constitutes a double violence against liberty." He held it up. The court clerk approached, accepting it as supplemental material. Justice Thomas visibly nodded. The air changed, not with noise but with weight. What began as a courtroom challenge was now a historic exploration, one that forced the justices not only to review precedent, but to re-examine the very philosophical roots of American property rights. Justice Thomas finally spoke. "Mr. Washington, your originalist analysis is well argued, but I must ask, would this court, in your view, need to overturn Bennis v. Michigan in order to rule for the petitioners?" Denzel's answer came crisp and prepared. "Justice Thomas, while I believe Bennis was wrongly decided, the court need not overrule it to find for the petitioners in Henderson. Bennis involved a vehicle used in direct criminal conduct. Henderson involves a community center. No charges filed, no criminal nexus, only an indirect association. The distinction is meaningful and doctrinally sound." It wasn't just a good answer. It was a strategic answer, crafted not to challenge the court's integrity, but to invite its evolution. The bench was no longer analyzing a brief. They were listening to a colleague. Chief Justice Roberts cleared his throat. "Mr. Washington, assuming we accept your framework, what test would you propose courts apply in evaluating future civil forfeitures? Question like that is reserved only for the most respected attorneys. It's not a challenge. It's a request." Denzel, without missing a beat, raised 3 fingers. "First, the government must show a substantial connection between the property and criminal activity, not hypothetical but demonstrable. Second, where personal jurisdiction exists over the property owner, the government must either secure a criminal conviction or prove with clear and convincing evidence that the owner knowingly participated. Third, the forfeiture must meet the public use requirement, serving a direct and remedial function, not just feeding state revenue." For a moment, no one spoke. The man who had once been accused of not understanding constitutional law had just drafted a new constitutional standard in real time. Justice Sotomayor looked to Roberts. Roberts looked at the clock. Denzel's time had run over. But no one interrupted him, because in that room at that moment, the question wasn't whether Denzel Washington belonged in the courtroom. The real question was, who else in the country could have delivered that argument? 3 months after the oral argument, a quiet but powerful document shook the legal world. The Supreme Court, in a 7-2 decision, ruled in favor of the petitioners in Henderson v. Department of Justice. The court had not only limited the government's all-wide civil forfeiture powers, it had embraced the very framework Denzel Washington proposed. Even more shocking, the majority opinion was authored by none other than Chief Justice John Roberts. His opening paragraph was as deliberate as it was humbling. "After careful consideration of constitutional text and historical record, we find that civil forfeiture, as currently practiced, exceeds its original constitutional bounds. When property is seized from innocent owners with no criminal charge filed, the Fifth Amendment's guarantees are not respected. They are bypassed." 4 separate footnotes cited Denzel Washington's oral argument directly. One of them read, "We commend counsel for amicus curiae for exceptionally thorough historical research, which illuminated founding-era understandings often overlooked in modern doctrine." Across the country, law schools updated their syllabi. Legal blogs exploded, and the phrase "the Washington framework" became shorthand for a 3-part test that would now govern future civil forfeiture reviews in federal courts. But the ripple effects didn't stop there. Property worth millions was returned to churches, schools, and non-profits who had been swept up in broad forfeiture efforts. Several state legislatures introduced reforms modeled on the ruling, and grassroots justice organizations received new funding and support, many directly inspired by Denzel's quiet revolution. The story went global. The New York Times ran the headline, "From Stage to Supreme Court: How Denzel Washington Changed the Law." A 60-minute special followed. So did a Time magazine cover, but Denzel? He stayed silent until he reappeared at Georgetown Law School 6 months later, on a small panel about civic education. Seated beside him, Chief Justice John Roberts. Their exchange was respectful, candid, and, at moments, wryly humorous. Roberts admitted, "I underestimated him, not just his preparation, but his principles. I thought I saw an actor looking for a spotlight. What I found was a scholar defending justice." Denzel simply replied, "The law doesn't care who you are. It cares what you bring. All I brought was 5 years of quiet work and a belief that the Constitution means what it says." In that room, no one laughed, no one clapped. They just listened, because Denzel Washington had done something most believed impossible. He hadn't acted like a lawyer, he'd been one. And with grace, evidence, and unshakable preparation, he reminded the highest court and the country that brilliance can come from unexpected places. Sometimes, even from seat A1 in a courtroom built for legends. Denzel Washington didn't just walk into the courtroom, he walked into history. In a world where assumptions too often silence brilliance, he proved that excellence doesn't wear a uniform, speak with one accent, or come with a traditional resume. It rises from dedication, from discipline, from a belief that justice must mean something. He stood up, not with anger, not with celebrity, but with truth. And the system listened. So the next time someone doubts your worth based on where you came from, how you look, or what you do for a living, remember this: preparation can silence power. Presence can reshape institutions. And one voice, backed by truth, can challenge the highest bench in the land. Share this story with someone who needs to be reminded. Brilliance can come from anywhere. Like if you believe in the power of unexpected greatness. Subscribe for more stories where justice is reclaimed and voices break through. Because sometimes the loudest arguments are spoken in the calmest voice.